Hey there, in this video, you'll learn a secret that I guarantee will help you win your restraining order hearing, how to expose the other party's lies to the judge. My name is Veronica. I am a domestic violence restraining order defense attorney here in California, and I help people put their cases behind them so that they can enjoy their lives and their freedom. I'm also the creator of a course called Defeat the DVRO, in which I teach you from start to finish everything that you need to win your hearing in an easy to follow, fill in the blank type of format. If you're interested in that, you can actually find your free first class down below in the description box. This video is part of a 3-part series that I have created and published this week. This is the final part that contained the top 3 secrets that you need to know if you are planning to represent yourself at your restraining order hearing and you want to win. Okay, so the easy way to expose the other party's lies at a restraining order hearing. Let's go. Secret number 3, learn how to discredit the other party. Now, the key point here is that you can't approach a restraining order hearing the same way that you would approach other arguments with your ex. You need to know how to ask her questions in court and how to poke holes in her story. Now, let's go through a key example of how to discredit the other party. This is cross-examination style number 2, which I like to call, and I've nicknamed, were you lying then or are you lying now? If the petitioner changes her story from what she wrote down when she was trying to get the restraining order and what she says in court, you want to bring that up. But how do you do it? After she makes her statement, as I mentioned, you get to ask her questions. Now, I highly recommend typing out the petitioner's statement and bringing a laptop so that you can easily locate her prior statements during the hearing when she's testifying. I like to use the search tool, the find tool on my computer, especially if it's a really long statement that she hand wrote. How are you going to be searching through that during the hearing and also listening? It's too difficult. You want to be fast. That's one of my key ways that I win trials, that I win restraining order hearings, is being fast, being able to locate that. I think that that's a killer secret. I don't know a lot of lawyers who do that, but it works so perfectly. Now, be careful. Use this only for important facts that would not be easily forgotten. Don't use this for every small detail. I'm emphasizing this because I've had clients, both in criminal and in domestic violence restraining order cases, that really want every single one of these details to come out. And if I do it as a lawyer, the judge will probably get annoyed with me. But if you do it as the respondent, you're going to look bad. You're going to look nitpicky. You're going to look the opposite of how you want to look, and you're going to make it that much easier for her to get the 51%. So don't do that. Okay, so here's the scenario. The petitioner wrote on her request for a domestic violence restraining order that during an incident that she claims happened on Thanksgiving Day, you struck her in the back of the head. So that is what she wrote down. She never mentioned anything at all about being hit in the face, but she has now testified. Now, today in court, she's testified that during that same incident on Thanksgiving Day, you repeatedly struck her in the face, not in the back of the head. Pretty big difference, right? So how do you point that out? This is how you do it. Your first question will be, you testified a few minutes ago that on Thanksgiving Day, I struck you repeatedly in the face. She's going to say, yes, that was my testimony. Second question, you're absolutely sure that I struck you in the face. Now, this is what I'm talking about when I say make sure to commit her to it. You want her to say she's absolutely sure, because then when you pull out the statement that she made before that is completely different, it doesn't give her wiggle room to say, well, maybe I forgot, or I wasn't really sure today, or I haven't had my coffee this morning. It takes away those excuses. That is key, because those excuses will come, and you want them to fall flat. You want her to lose credibility, and you want it to be impossible for her to get 51%. You wrote a statement as part of your request for a DVRO describing me hitting you on Thanksgiving Day, correct? She's going to say yes. And you signed that statement under penalty of perjury. Well, yes. You promised to tell the truth the same as you promised today, correct? She's going to say, well, yeah. And then this is the part, this is the zinger, right? Isn't it true that on your DVRO, you wrote, he struck me in the back of the head? And she might say, yeah, but the judge won't like that. The judge is going to want her to just answer the question. And really, what can she say, right? She's already changed her testimony and she's already committed. She said she was absolutely sure. Isn't it true that on your DVRO, and this is the super zinger, you never mentioned anything about me hitting you in the face? You got her. How is the judge, if you use this question format, if you bring this up, how can the judge believe her? If you're still watching, you were probably pretty serious about winning your restraining order hearing. So you can keep binge watching on YouTube, hoping to find the answers, or just go and get them. Click the link down below, take your free first class. You have nothing to lose. Thank you for watching. I hope that this video helped you. And if you did like it, make sure to give it a thumbs up, subscribe, and ring the bell.